Good afternoon. The Senate Finance Committee is in session, and we'll begin to hold a hearing momentarily. Let's see. Initially, we're going to hear from Senator Delegate Pena Melnick. Come on up for House Bill 287.
Thank you. Good
All right.
afternoon, Chairman and Vice Chairman and members of the committee. Thank you for allowing me to present to you House Bill 287. So you heard 287 and it was on the floor and it got recommitted back here. Though I will ask respectfully that you pass the bill respectfully the way it left the House with no amendments. It's a very simple bill. The Secretary of Health is responsible for managing a budget that will reach $18 billion next year. The largest percentage of the state budget and nearly 1/3 of the total spending. Agencies under the Secretary's purview include the Public Health Administration, the Behavioral Health Administration, the Developmental Disabilities Administration, and Maryland's Medicaid, which serves almost 1.6 million low-income Marylanders. Among many other critical functions, these agencies oversee all local health departments, the Office of Health Care Quality, and the Maryland Primary Care Program. The Secretary also oversees a variety of essential operational functions, including the state hospital system and the Office of Preparedness and Responses. And 28 other states do that, where you require the Secretary of Health to have some health background. We do that. If you ask, well, who else is doing that? The Secretary of Budget and Management. We ask the Secretary of Budget and Management to have a background in public financing, budgeting, and management. We ask the Secretary of Disabilities to have extensive experience and knowledge of disability laws. We ask the State Superintendent of School to be an experienced and competent educator. We ask the Secretary of Information Technology to have experience in information technology. We have spent this session, I'm very proud with this committee because our bills cross each other. We have done amazing work on public health because we have underfunded public health for a long time on behavioral health as well. And this person that leads this department, the Secretary of Health, must be experienced, and 28 other states do it. I ask respectfully that you give it a favorable report and that you pass it, again, respectfully in the manner in which the House passed it without the amendment.
Thank you. Other questions? Senator Feldman?
So, Jocelyn, as you mentioned, we did pass the bill out, and then we ran into a little pushback on the amendments that had added all the deputies. So, anticipating we may have somebody get up on the floor and offer an amendment, give the committee maybe some idea as to why we should try to resist or move forward clean and if there is some attempt to revisit the issue of all the deputies and that kind of thing. That we might want to wait to do off on this, stay off on that.
And I would thank you for crossing the bill.
Yeah.
Thank you so much for doing that work. I would say keep this bill simple because this bill, the original intent was to deal only with the position of the Secretary. We never had a discussion on the deputies and what the implications of those may be. And the House didn't have that discussion. And I would say if you're going to discuss that bill, do it another year. But for this year, we're keeping it simple with the Secretary of Health. And as you know, we have lived with COVID for the last 2.5 years and have almost 3 now. And that position is so important. And again, 28 other states do it and other departments here do it as well. So I would ask that if that amendment comes on the floor, that the committee resists taking it. Keep it simple. Simple is good.
Thank you. No other questions, so thank you very much for your testimony.
Thank you, Chairman. Thank you so much. I appreciate you.
All right. All right. We're going next to Delegate Chang, Maryland Stadium Authority membership.
Good afternoon, Madam Chairwoman Kelly and Vice Chairman Feldman and members of the Senate Finance Committee. Appreciate the opportunity this afternoon to present House Bill 20, which is the Maryland Stadium Authority membership. My name is Mark Chang, member of the Maryland House of Delegates, District 32. What the bill would do would increase the board number from 7, which currently is, to 9. The 2 additional members would be members that are appointed by the Senate President and also Speaker of the House. Currently, there are 6 members who are appointed by the Governor and 1 member who is appointed by the Mayor of the City of Baltimore. And by legislative direction, They manage and also oversee the construction of many different projects throughout the entire state, whether they be the sports complexes in the city of Baltimore or over in Hagerstown with a athletic facility over there, or with school construction, for example, with the Built to Learn and also with the 21st Century School Construction Program. So with these billions of dollars that the legislature has approved and allocated, it's important that the legislature has feedback and input into the Maryland State Authority and its operations and also how it deliberates on different decisions. With that, I ask for a favorable report. Thank you very much.
Thank you. Are there any questions? All right, very good.
Thank you
Thanks
very
so
much.
much. Okay. All right, we're going next to Delegate Ampry. Work group on Black, Latino, Asian, Asian Pacific Islanders, and other underrepresented behavioral health professionals. You're on, sir.
Thank you so much, Madam Chair, members of the committee. Thank you for your time today. For the record, Delegate Marlon Ampry from District 40, here representing on behalf of House Bill 97, Work Group on Black, Latino, and AAPI community and other underrepresented mental health professionals. House Bill 97 is being introduced for the purpose of studying the shortage of Black, Latino, and AAPI community and those underrepresented groups in the mental and behavioral health professions here in Maryland, in order to eventually make recommendations on incentives and systematic changes or other methods to increase the amount of providers from these groups. We know that Maryland, recently we found out via our census data, we are one of the most diverse states in the union, but the unfortunate reality is that when it comes to mental and behavioral health, we do not have that diversity reflected. And it's important that we find a way in order to ensure that diversity is there. Studies show that when the physician is the same race as the patient, patients report higher levels of trust and satisfaction. Patients' visits also last longer on average. Furthermore, when it comes to cultural understanding, a lack of cultural understanding by healthcare providers may contribute to underdiagnosis or misdiagnosis of mental illnesses in people from racial or ethnically diverse populations. Factors that contribute to these kinds of misdiagnosis include language differences between patient and provider, stigma of mental illnesses among minority groups, and cultural presentation of symptoms. Developing policies that incentivize Black, Latino, Asian, and other underrepresented groups to enter the mental health profession will serve these communities with complex historical and cultural needs is an essential step in improving mental health outcomes for our increasingly diverse patient population here in Maryland. Access to caregiver that is culturally competent is a basic human right, especially during this time when mental health awareness is at an all-time peak, and especially given coming out of COVID. We know COVID has had a major impact on mental health. Most recently, in the Baltimore City delegation, we were visited by our superintendent, our CEO, and she pointed out that we are in dire need of providers that have a cultural and ethnic connection to our student population. If we don't have that connection, she equated it to essentially as being a warm body in the room because they're not able to connect with our students. We really need that. And I'll keep it brief, but I want to make it clear that we have a lot of support for this bill. We have support from the Black Caucus, Latino Caucus, the API Caucus, amongst many medical networks throughout the state, along with our HBCUs and other educational institutions. And I really urge the committee for a favorable report, and thank you for your time.
Thank you. Let me just ask, who will be staffing the work group if the bill passes?
The bill lays it out. There'll be a mixture of, let me pull it out real quick. So we'll have members from who will be appointed by our HBCUs across the state, along with those from different hospital networks, 3 representatives from the behavioral health profession in the state, 3 individuals who provide social services in the state, and at least 2, but not more than 4 representatives that organizations, networks, or associations of behavioral health professionals that particularly service our communities of color. So if you look on page 1 and 2 of the bill, you'll see that we have a really diverse collection of individuals that will be involved on all aspects, from the recruitment process to the education process, to the actual licensing process, to the actual community work that needs to be done. And I think this, these collection of people will be a really good group to make sure we get the best service provided.
Thank you. Are there any other questions? All right. Thank you very much.
Thank you.
All right. We're going next to Delegate Watson. Is she not here yet? We'll need to take a brief pause, but wait, we've got the next two speakers are trying to,
Clippinger's on his way.
yeah. Delegate Watson, you may come to the podium for HB 4, Unemployment Insurance Recovery of Benefits, Refund of Payments.
Thank you. And it's very nice to be here in person and without a mask for the first time in 2 years. Good afternoon, Chairman Kelly, Vice Chairman Feldman, and members of the committee. Thank you for allowing me to present House Bill 4. This bill passed out of the Economic Matters Committee with a vote of 19-3 and passed the House of Delegates on March 4th with a vote of 125-0. Like you and your staff, my office has handled hundreds of constituent inquiries about unemployment benefits since April of 2020 and continues to do so today. This bill originates from a constituent matter which is one of the most challenging we helped resolve. To summarize, the Labor Department extracted $3,440 in a duplicate overpayment from our constituent, Veronica Christensen, starting in November 2020. After months of inquiry and inaction, she finally brought the matter to me in my office in August of 2021. We tried to help her, and we witnessed further inaction, ineffective communication methods, and lack of coordination from the Labor Department units that combined to cause extremely poor constituent service. I'm not going to torture you with all the details, but if I did give them to you, you would shake your heads and you would say, you can't make this stuff up. On September 28th, 2021, the department finally approved the repayment to Ms. Christensen. As to when she could expect her refund, she was provided the following response from the Benefits Control Unit staff. Quote, as I previously explained, the $3,440 refund was approved on September 28th. We are working on all the refunds as fast as possible. I have inquired about the status of your refund and was told that there is a backlog. We hope to have the backlog cleared within 3 to 4 weeks. On November 10th, 2021, a check was issued to our constituent exactly 1 year after the overpayment was extracted by the Labor Department. HB 4 establishes a process that the Secretary of Labor must follow when the department is notified by a claimant that an overpayment by the claimant has occurred. Following the recovery of benefits from a claimant, if the claimant notifies the Secretary that the actual amount recovered exceeds the amount in the stated recovery notice, which was the case here, the Secretary must investigate the claim within 30 days after receiving notice, and within 14 days after completing the investigation, refund the claimant any difference that is owed the claimant. Question is, how are we to know how many people this affects? How many people are still out there that have this problem? To remedy that, the bill has a requirement that the Labor Department submit to the General Assembly a report each month with the total number of disputed claims being investigated, the status, the amount of funds in dispute, and the legislative district of the claimant, and the date any funds were returned. Thank you for the consideration of this bill. I request a favorable report, and I'm happy to answer any questions.
Are there any questions? Sounds like a very timely bill.
Yes.
Thank you.
Thank you.
Okay. All right, we've got to take a pause. We are waiting for Delegate Clippinger, who is testifying elsewhere. Colleagues, please be seated. Chairman Clippinger is here. You may either stand at the podium or sit at the table if that's more comfortable and you've got papers, whatever you
Chair of
prefer.
Judiciary, I feel like this is probably like talking to a version of the Supreme Court, so maybe I
Oh,
should do it
shucks.
this way. I'm not sure. Don't tell JPR except, oh dear.
Okay. And he's testifying, I think, concurrently on House Bill 1 and House Bill 837. They're related.
Yes, and I apologize for the delay, but we had to get the Judiciary Committee up and running across the street. But
We understand.
Chair Kelly, Vice Chair Feldman, and members of the Finance Committee, and JPR, and I believe is Budget and Tax here too, or no? Just, okay. That's fine.
He may join, he's
Okay.
aware.
I appreciate.
But he trusts you.
Okay, that's fine. I appreciate. Oh, wow.
Okay.
Well, this is starting really well. What could possibly go wrong? I appreciate you and your staff for giving me.
Now, remember, we're online, folks.
I appreciate you and your staff for allowing me a few extra minutes for comedic relief and to provide a thorough overview of these two pieces of comprehensive legislation, House Bills 1 and 837. Last July, Speaker Jones announced her support for a referendum to legalize cannabis on the 2022 general election ballot. House Bill 1 is the legislation to put that referendum on the ballot, and I can talk about that a little bit more in a moment. When she announced her support for a ballot referendum, she simultaneously established the House Cannabis Referendum and Legalization Work Group and appointed me to serve as the chair of that work group. At that time, Speaker Jones tasked us with a clear goal: to consider the most effective and equitable path to implement a legalized cannabis program here in Maryland, should Marylanders vote in favor of the ballot question in November. Over the following months and up until the beginning of this legislative session, the work group and the work group subcommittee chairs, including Chair C.T. Wilson of the Economic Matters Committee, Vice Chair Moon of the Judiciary Committee, Vice Chair Pena-Melnick of the Health and Government Operations Committee, and Delegate Lutke of the Ways and Means Committee met several times to analyze different components of cannabis legislation and potential regulation. After identifying the key pillars of a successful legalization program and convening an initial organizational meeting, we continued our work examining the best paths forward regarding public health, criminal justice impacts, business implementation and regulation considerations, and effective taxation and revenue structures. And after those briefings over several months from experts in each of those areas, reviewing data and comparing successes and failures from other states and jurisdictions, it was determined by myself and my fellow subcommittee chairs of the work group and the Speaker that this legislation, House Bill 837, would begin to fully address those priorities. With this bill, 837, House Bill 837, it's our intention to begin to tackle our top priority, to begin to address the overwhelming disparities that have impacted people of color, especially Black and brown people, throughout Maryland with regard to cannabis. Specifically, what the bill does, we will ensure Marylanders will be able to possess up to 1.5 ounces, 42 grams of recreational cannabis without penalty starting on July 1st, 2023. Between the time that cannabis would be legalized on July 1st, 2023, and the time that the referendum would be certified, which would be on or about January 1st, 2023, possession of up to 1.5 ounces would just be a civil fine. Now let me take a pause here and just make it real clear. There is a period of time in between the time that the referendum is approved by the voters and the result comes back, and that cannabis would actually be legalized under this bill. So between those 2 points in time, January 1st and July 1st, there would be still a civil fine in place for possession of up to 1.5 ounces of cannabis. We also make changes during that time to the statutes regarding possession with intent to distribute that would start on January 1st, 2023. It would change that from a felony to a misdemeanor, and we create a crime specific to the sale, the unlawful sale and distribution of cannabis. We also, on January 1st, 2023, anybody who was held in custody for possession of marijuana would be released, and we would begin the process by which people could get their records expunged of what we call the single-shot cannabis convictions. So in other words, they were only convicted of cannabis. Those convictions would be expunged automatically. We address public health concerns in this legislation. It requires the completion of a baseline study that gathers data on the patterns of use, incidents of impaired driving, issues related to prenatal health, hospitalizations, and calls to poison control and use disorders related to cannabis. The data would allow us to have the necessary information as we legislate in future sessions and to provide support to vulnerable communities. In tandem, we also create a Cannabis Public Health Advisory Council funded by a Cannabis Public Health Fund, which, by the way, also funds the study that I just mentioned. And that Cannabis Advisory Council would make annual recommendations regarding impacts to youth, addiction, infant development, advertising, labeling, and quality control of legalized cannabis. Finally, on the public health front, we apply the Clean Indoor Air Act to cannabis because we should preserve the right for non-cannabis users to have access to smoke and odor-free indoor air. The bill also begins the planning, I should say, to build an equitable licensing structure for the sale of recreational cannabis, and begins that process by creating a disparity study. And it creates a disparity study to allow us to look carefully at the barriers that confront Black and brown communities as they seek to participate in the sale of recreational cannabis. The disparity study would begin upon approval of the legislation of the bill that I was mentioning before, 837, which I suddenly forgot the number, and I'm not really sure how I did that. But in any case, it sets out a disparity study that would begin right away and would come back with recommendations before the 2023 session to allow us to come forward with legislation in the 2023 session that could properly identify and seek to ameliorate or eliminate those barriers as we set up the next licensing system. The legislation also creates what I have called a social equity fund, one that's capitalized, we would hope to capitalize in a final approved state budget to provide operating, financial support, and educational assistance for minority business owners to participate in this new industry. Again, that fund would be funded this year, or in fiscal 23. It would be funded right away to give people the opportunity to begin the process to figure out what they would need to do to participate. I would say that, while the promise of perfect policy can't be guaranteed, and I'll take a little side note here, there have been 18 other states that have done this. I don't know that anyone has done it perfectly. I think we've tried to take a lot of what we've been able to determine works in other states and put it into this legislation. I can't promise that it is going to be perfect. We do need to learn also when other states have run into problems with obstacles in their implementation process. And you can look around the country at challenges that people have faced in Maine and in other places related to their recreational cannabis programs. I believe this legislation responds to those missteps and ensures that we get our program right and get our program right to the very best of our ability. We considered this legislation through our committee process in the House. It is different from when it was first introduced. We include language related to what we call sharing, what is called sharing. A person can share cannabis if they're sharing it with another person who is over 21 without remuneration. The rough equivalent would be that if somebody had a beer and they were sharing a beer with another person, that they could do the same thing with cannabis without being charged with possession with intent to distribute that cannabis, which would carry a much more serious offense. We also indicate that cannabis would not be able to be consumed in a public place The first violation would be a $50 fine, and the second violation, a $150 fine. And ultimately, after the House Bill 837 works its way through the General Assembly's process, Marylanders will then have their opportunity to speak at a referendum and determine whether or not they want cannabis to be legalized. And that's fundamentally, again, what House Bill 1 does. It puts the question on the ballot. It doesn't do anything else really other than that. And I think that is certainly something important to me, important to the Speaker, and I think it's important for people in the state to say, here, we're okay with this, basically. I think also what our bill has sought to do is to answer the questions that people will have when they consider whether or not to vote yes or no on that referendum. It seeks to address issues related to, okay, so what happens next? How much can I have? Where can I use it? What are we doing related to addiction? And it begins the process to look at who can sell it and how we can encourage people who have been left out of the market in the past to be able to come into the market and truly look at this process through a lens of equity. With that, I know there are a number of other issues I could talk about, but I think I've talked about 7 to 10 minutes, and you haven't fallen asleep, so I would be happy to take any questions that you have, and we can go from there.
Thank you. You did a good job. I do have one question. I think it's about THB.
THC?
THC.
Right.
Okay.
THB is Towson Hot Bagels.
You're
It's
right,
located
you're
on
right,
Clinton
right.
Street in
And
Canton and in
THC.
several other
Oh,
locations.
I'm
It's a
talking about
lovely
the
place.
chemical residual from having been around the smoke.
Yes.
Which could impact other people that are there and which can stay in the human body and be detected through testing for 7 to 10 or more days.
Or longer.
Yeah. Have you guys thought about how to handle that issue? Let's say if there are children around, or if you're in locations where there are people with disabilities around who could end up with it. But even more so, the idea that the police stops you for something, maybe for poor driving, and then they decide you appear to maybe be impaired, but something could be a beer, but they find the THC in the blood when they test. What have other states who've already gone ahead done about that? Because that's a problem area.
This is probably what the broader issue of odor and how other people are impacted by exposure to smoke, but then also how that interacts with criminal justice issues is kind of one of the bigger issues. And we touch on it a little bit, but I kind of want to, if I could have some indulgence, sort of unpack a couple different things. One of the bigger issues that we I think are still going to have to address and may need to address even in this legislation has to do with police officers who come up, particularly at traffic stops, and they come upon people who have where there is the odor of marijuana, and it is not an uncommon thing where a police officer may see bad driving, may see driving that perhaps in some ways is similar to driving under the influence of alcohol. They see the bad driving, they conduct a traffic stop, and they confront that odor. Right now, under Maryland law and under the jurisprudence from the Court of Appeals, that will allow the police officer, if they have probable cause, they believe that marijuana is in the vehicle, they can search the vehicle. That's one issue that is still out there that the legislation doesn't completely address, and that we're continuing to have conversations about in the House, I will say. But it goes back to a more challenging issue than the issue that you're bringing up with, well, we don't want to encourage people to drive impaired. And that is that's been a huge concern of people in the House, and I know of the Speaker in particular, where we need to make sure that police officers are able to properly investigate those times when people are driving under the influence of cannabis. The step beyond that, that is a little more challenging, that I think is something we're going to have to deal with in the long term as tests become available for driving under the influence. We really don't have a good test right now that can determine in the same way that a breathalyzer does for alcohol. You don't have a similar test for marijuana. You don't have a breath test that says, okay, this person is over some per se limit that says they're high. That technology really doesn't exist. It doesn't mean it's not possible that it shows up in the next several years. But what police officers do in this case and other cases is they can still go forward and say if they see bad driving, they detect the odor of marijuana in the car, they can still go forward and say it's still driving under the influence. It's driving under the influence under 21902C of the transportation article. So they'll be able to go forward on those, on that as it stands right now. And there's nothing in this bill that would change that. So my very long-winded Judiciary Committee answer to the question is there's existing law that addresses driving while impaired, and this doesn't do anything to change that. Which is what I probably should have said, but you know.
Okay, we've got several questions. Senator Hershey.
Thank you, Madam Chair. Mr. Chairman, thank you for your comments. A question. HB 837 is contingent on the passage of HB 1 and the ratification by the voters, correct?
It's contingent on, yes. It is contingent on the passage of the referendum by the voters, yes.
Right, okay. So why have we decided to do it that way? A referendum or constitutional amendment is not necessary to enact HB 37 on its own. Why have we decided to go forward with a referendum that links back to this piece of legislation?
I think that and speaking again I'll speak for myself and I know for the speaker, that she feels very strongly that people get the opportunity to have their voices heard on this issue. I think that what we have observed, certainly in the House, is that people, this is one of those issues where people feel pretty strongly one way or the other, and they feel like they want to hear. I think we feel, at least in the House, that their voices should be heard one way or the other as we make a pretty significant change to the way that we deal with this particular controlled dangerous substance. This will be one of the first times that arguably one of the first times we've legalized a controlled dangerous substance, at least certainly in recent memory, if not ever. And so because I think it's a bigger deal and a bigger difference, I think it's right to get that sign off from Marylanders in the November ballot.
Based off of all of that you said, and that makes a little bit more sense, but the phrasing of the constitutional language is actually pretty vague, I think. Also, that language is usually written by the Secretary of State, right? So in this one, you guys have decided to be very specific on what the ballot question will look like, but then you gave me a pretty interesting response to why we're trying to do it. This just simply says, do you favor the legalization of adult use cannabis in the state of Maryland? So, you might have people vote on that and think, yeah, go ahead, I do, and, the day after the election think that they can light up and start smoking again. This bill that it ties into is so much more complex than that very simple question. So if I were to go back to why you said it's necessary, they just don't seem to jive too much. They don't seem to, your explanation doesn't seem to make sense with the question, the very simplistic question that's on the ballot, would be on the ballot.
I think that part of the challenge here is that when we go into the regulation, we approach it from a slightly different direction. Let's say we had not legalized alcohol, and now we were seeking to do the entire regimen of all of the regulation that we do related to alcohol and put that on the ballot for people, using the same argument that I used before, that it's important for people to be able to say one way or the other that they support the legalization of alcohol. the volumes, there are two of them, of the alcoholic beverage article would be significant and honestly not incredibly helpful in some ways for people to really truly understand what is going to happen with that. Fundamentally, the issue here is we are seeking to legalize this substance that has not been legalized before, that has not been legal before. That is the sum and substance of the question. How it is regulated, how it is sold, the public impact, the public health impacts that we're going to face with it, all of those things, I believe, they are to some degree secondary to that very fundamental threshold question, which is why it is stated the way it is and tried to be as clear as we could be.
Right, but going to the alcohol explanation, I mean, we had a very complex question on the budget a few years ago. I don't think many of the citizens still know what that referendum question did, as complex as it was. But again, what you're stating here, do you favor the legalization of? Yet, I think what you even said about HB 837, that the main priority was the expungement, vacating, and resentencing issues of criminal justice.
The
top
those
priority,
are
I
some
think, was the word you
the top
said.
priorities are from a broader perspective, are certainly looking at how this has impacted Black and brown communities and figuring out ways that we can ameliorate the difficulties and far worse the difficulties that have happened in those communities related to how we have dealt with marijuana in the past. But what I'll again say, these are all of the things that go into all of the things I talked about in H37. They're part of that regulatory structure. We're not necessarily asking people whether they approve to every part of the regulatory structure. We're asking them whether or not they support the legalization of cannabis writ large. And that I think is the fundamental threshold question that we need to hear from people about, and that's why we support that referendum.
All right, and final question, because over here we did work on legislation and, again, going back to a referendum question really not being necessary. Last year we had two bills that dealt with the legalization of them. They stalled. This year we have a bill over here that does address the industry, that does address licensing, that does address what I really think people believe that they're voting on when they vote on this question. We believe that you as the legislature should have put a process in place that once we say yes to your question, then it will move forward. Okay. We've, in a sense, just kind of kicked the can down the road and said, okay, we'll do something on or around January 1st after the voters come back. And this is the same way that we handled sports betting, and we saw that we got to a very late start with that. We haven't done this with other things. I think that it could have had, and I guess I'm asking why your bill didn't have the industry-type language that the Senate bill has, why you didn't go forward with how we would go into the legalization, how we would go into the process, how we would go into taxation of that. Why weren't those in the House bill?
Because we believe that we need to do a disparity study that will look at the impacts to Black and brown communities and Black and brown people who want to participate in the process. And if there's one thing that we learned from when we did medical marijuana, is that we didn't do that very well. And it resulted in an impact that resulted in, frankly, a knockdown, drag out before that program was actually able to get going. I understand, so we need to do that disparity study. We have one on medical marijuana that was done in 2017. We need to do a new one to make sure that we are taking a real and honest look as to where we stand, because we need to address those issues. The reason why then we also are, part of the reason for the referendum is we can do this referendum, we can get sign off from people from across the state, and then come back in the 2023 session with that clear statement from people across the state and deal with those issues with the information that we need and the data we need to be able to go forward. So that's why we're proposing it in the way that we are. Again, it's, July 1st, 2023 would be the date that we would move towards the full legalization, and I think that is going to be enough time for us to begin to set up those regulatory processes.
So then just based on what you said, when does the disparity study take place?
The disparity study would take place upon, whenever the 837 became law.
When
So in other words, if the
837
governor signed it, or if the governor allowed it to become law, or if we overrode a veto, the disparity study would begin to move forward at that point so that it could be done prior to the 2023 session.
And that's why there's certain sections in the bottom of that
Correct.
that are
There's-
dependent on HB1 and some of
That's
them.
exactly right. We've sought to kind of, it's almost a run of show. We've kind of tried to lay it out piece by piece by piece so that we can keep things moving. Fundamentally, and you pointed out quite rightly, Senator, we have been talking about this for quite a while. Here's the first time that we've got a bill that's come across the street, and it's been a long time coming. I think that now is the time to continue to make the progress on the legislation, and I think that this process does what we need to do. It addresses the issues that we need to address, and I think allows us to move forward on this really challenging issue.
Okay, I appreciate your
Okay.
responses.
Thank you.
Thank you, Madam Chair.
We're going to, in the following order, Senators Hayes, Augustine, Reedy, Jennings, and Benson.
Senator Hayes.
Okay, so Hayes, you're next.
Thank you, Madam Chair. Quick question, Mr. Chairman. You had mentioned the Social Equity Fund, and then I think I read something in here about the Cannabis Business Assistance Fund. Are they
That's-
one and the same?
Talk into your mic so we'll all hear you.
The Cannabis Business Assistance Fund and what I have called the Social Equity Fund. I should have said the cannabis, thank you for correcting.
Got you.
It is the
Okay.
cannabis business.
Right, and so with that fund, the sole purpose of it is to support related businesses to enter the marketplace. There's no other purpose for this fund.
I'm going to go back to the bill to make sure that I'm quoting it exactly, but that is the intent of the fund, is to be able to do that, yes.
Got you. And so, in line with Senator Hershey, this is the first time that I remember doing a constitutional amendment. Are there certain restrictions in what can be in a constitutional amendment, or it's pretty much to us as a legislator? I see we've gone as far as identifying the question, which from what I heard is unusual, but are there additional restrictions on what can be provided in a constitutional amendment?
I mean, if my memory serves, I believe the Secretary of State's office will either take the question that is, as it's introduced in the bill, or they can draft further information that can be provided to people as part of the ballot.
Got you. And so, and part of your testimony was really that, part of this is to address some of the adverse effects on the black and brown community, but in the referendum itself, there's no remedies provided for either for these demographics. I wonder, what was the thought behind that omission?
The thought behind not referring to black and brown
Not
communities
providing any remedies to the disparities that have happened to those communities.
Because again, what we want to do and what we propose is we want to make sure that we're doing what we need to do constitutionally, what we need to do to be able to properly go through the process and make sure that we identify the barriers that are out there through the disparity study, and then come back in 2023 and put together the regulations that need to be put together in order to set up the sale of adult use cannabis.
All right, I guess that's where I'm kind of getting stuck on the disparity study. Like, we've known that adult use was coming for some time. There's been a lot of research around this, and even, something that we don't often see in legislation that's introduced in the legislature attached to this bill is an impact study that would have been provided by the Department of Legislative Services, which has a tremendous amount of data. So what helps inform us that we would be required to do a diversity study as opposed to the information which it looked like Legislative Services put together a pretty comprehensive document legislating the disparities here in the state and have put a lot of research and charts along to support it.
The disparity study is something that is done and that we have done in other contexts, I believe, in the past, that allows us to then say, okay, here are these very specific barriers that people have to involvement in the market. If you want to, then if we want to address, which I would hope would address those very specific barriers to people entering the market, the program can be carefully crafted then to address those specific concerns. This is part of what we have to do in order to meet the legal requirements that we need to be able to meet to actually address Black and brown communities and other people who have been negatively impacted by the criminalization of marijuana over time. We have to be able to show that direct connection, and we have to look at it in the context of almost strict scrutiny, of being able to say this is connected to that, and we are doing this because of this specific harm.
Right. So stated another way.
The disparity study and the way the disparity study is done, it is the way to be able to demonstrate we've done this. We've also looked at non-race of ways to go forward that aren't related to race, and we may look at all of that information and legal beagles can come back and say, okay, we don't need to do this, and this. We need to do this. We can use more non-race, race-based ways forward. So but we have to have that information. We have to have that data.
Right, but if you look at the impact study, and I'm not a lawyer, nor do I play one on television, but
Neither do I.
they put quite a bit of information in there as it relates to demographics and other things. Is it a question of legality on whether or not that document that they've put together meet the threshold by which to measure the diversity?
That's effectively, that is what you need to be able to demonstrate what needs to be done in order to eliminate specific barriers to specific groups of people. It's an entry point to make sure that you can go the rest of the way.
Gotcha. And then the last question, Madam Chair, and thank you for your indulgence, as it relates to stops and the odor. And so I understand that an individual, they can't be detained just for the smell of odor, but if there is some observation on behalf of the law enforcement officer that they may be impaired, is that the threshold by which this bill spells out?
So
can you help me with that a little?
I'm going to watch the clock behind, and if I get to the next bird that's there, I'm going to try and stop. So I'm also my aide Dylan is here, who will throw something at me if I get too wonky on the prosecutorial side. The Court of Appeals has been moving steadily in this area of the law, and what they've said is that if a police officer should walk up to a person on the street, nothing else, but smells the odor of what they believe, based on their training, knowledge, and experience, to be marijuana, they, in the past, could stop that person and do a search based on just that odor. The Court of Appeals has now said, no, we're not going to let you do that. We're not going to let you do that because the odor alone doesn't trigger that ability to search, because we have already in law said that under 10 grams of marijuana is just a civil offense and not a criminal one. So they've already gotten to that point. There have been several cases that have come up since then that deal with the odor of marijuana coming from a car as opposed to coming from a person. And the Court of Appeals has gone in a different direction with regard to the odor coming from a car, because the argument there, in part, is we want to look at the potential that somebody is driving impaired. And what the Court of Appeals has said there is, we're going to allow you to search inside, effectively, the cabin of the car. We're not going to allow you necessarily to get in the trunk or anywhere else, but we're going to let you get anywhere within the arm span of the car, of the interior of the vehicle. This is one of the more challenging issues related to this issue. And in candor, we did not touch this issue in the House bill. I think it's something that certainly we are still talking about in the Judiciary Committee and in the House. I'm certain that it will be part of conversations that I hope we'll have with Madam Chair and with this committee and the Vice Chair and anybody who'd like to participate, because it goes to an issue, a very, very clear issue where if you are in possession of a legal substance and you smell, and a police officer smells the odor of what is now a legal substance, can they stop you? The Court of Appeals has said if they're on the street right now, that's one thing. But how does that interrelate with a car? How does that interrelate with impaired driving? And that's where you get into sort of the challenges with where things stand. So we broadly have stood saying the Court of Appeals has already spoken to this subject and is continuing to speak to the subject. And I'll say, in their most recent opinions, has been pretty explicit of almost saying, not really almost saying, we're doing this because the legislature hasn't decided to formally legalize this or not.
Got you. And I thought that was my last question, but this is truly my last question. I am concerned, and I find it somewhat offensive that we say that this is to address part of the legislation is to address the disparities that have existed in the Black and brown community, but there's nothing in the referendum or other thing that would go forward in the very beginning to provide some restitution or reinvestment to these communities that have been disproportionately affected. And so my question is, would there be any objection to language being added to the referendum to ensure that there's some type of reinvestment to those communities that have been disproportionately affected?
I don't know that the language necessarily needs to be added to the referendum question in HB1, but what I would point out to you is in HB 837, the Cannabis Business Assistance Fund does provide grants or loans to small, minority, or women-owned businesses. It provides grants to the state's historically Black colleges and universities for cannabis-related programs and business development organizations to train and assist small, minority, and women business owners and entrepreneurs seeking to become licensed to participate in the adult use industry. And quite honestly, the next question, which would be wholly unreasonable, is, okay, so this is going to be about $20 million, and how could that possibly be any way construed to being reparative to anything that has been done related to the criminalization of marijuana? It's not. It's the beginning, though. And I think our feeling is in the committee is if we need to start here, and we need to start with that fund so that we can begin the process of seeding. There are too many marijuana references that I'm not going to stumble into one or two. To seeding and allowing some of these businesses to grow. And the only way that we're going to give, in my opinion, Black and brown people the opportunity to get in front of the curve for the adult use industry is if we start funding those now. And that's what it does. I'm sorry? The question was about the referendum. I mean, I think that the question regarding the referendum, our goal with the referendum was not to have an enormous amount of policy in the referendum, which it was to state a very clear question of whether you believe that marijuana should be legal or not. That's the threshold question. Whether the money should be used for any particular purpose, I don't necessarily believe has a place in the referendum, but at the same time, I take your point. I mean, the larger issue here is how are we going to deal with issues of equity? So I do take the point, but I think that from a practical perspective and from a legislative perspective, it's better to have a clean question and then deal with those issues in the policy bill in 837. That we will inevitably be talking about the details of as part of the referendum on HB1. It's going to be part of the conversation that's out there on the referendum. I apologize for my tongue.
To repeat, we're going next to Augustine, Reedy, Jennings, and Benson.
Thank you, Madam Chair. Thank you, Chair. There's some interesting information in here. I do want to follow up on what Senator Hayes was talking about, though, in 837, you talk about the disparity study, which does deal with the market structure. That doesn't have anything to do with tax revenue and how we would potentially use tax revenue to deal with the restitution and the things that Senator Hayes said, and we don't need a disparity study in order to determine where, or would you agree that we do not need such a study to make some decisions, which we've worked on in the bills that we have on this side? Would you agree that we don't need that the study deals more with the market versus dealing with actually how we would allocate the tax revenue?
I think it's very difficult to talk about the market for adult use cannabis independent of a conversation on taxation. I believe that you need to have a conversation about taxation at the same time that you deal with the issues related to how you're going to license it, because it fundamentally goes to, I would argue, the success or failure of those businesses that you're seeking to create. How you tax it and how you sell it and how you produce it are all intertwined in this issue. And again, as I think, as we've started to see in other states, when you take those issues independent of each other, it doesn't quite work as well. So I think that addressing those issues at the same time, and it's why we seek to do that in this legislation, addressing those issues at the same time in 2023 can truly allow us to use the information that we get from the disparity study to properly go forward with what we need to do to eliminate those barriers. And again, the tax questions all are connected to that. They are all connected.
The disparity study is not going to say anything about the tax question, though.
I completely agree. I 100% agree that is, you're absolutely right. I'm not taking issue at all with that.
Yeah.
And I understand, I certainly acknowledge that. But I guess what I'm getting at is, if you're looking at, you can't, I don't believe that we can say, here's the disparity study that's going to deal on the licensing side, but we're going to have already determined where all the money is going to get spent over here, and we've sort of taken away that piece of the puzzle as it relates back to the licensing structure.
Well, so what I would kind of say to that, Mr. Chairman, is that my constituents don't have too much trust. I'm just being honest with you, that if we don't do it up front, that it's going to actually end up back in their community. And so that is a struggle, I will tell you, of not sort of dealing with that up front. The second thing that I want to just ask you about is, you do have in there, which I thought was interesting, these triggers for the disparity study and a trigger also for a report from the Cannabis Commission, the study, to be completed in time for it to, what happens if those things don't get done? Because we know how that works out here.
Sure.
I mean, we heard testimony, actually, we had a pretty decent hearing information from the medical cannabis commissioner, who talked about how long the disparity study would take if it was, the different types. I'm sure you've heard it too. What happens if they don't? I mean, given that you're trying to say that those are things that you would like Marylanders to have as they're contemplating this decision.
I mean, all I can say is, in the conversations that we've had with people who have been involved with the crafting of the studies for other issues, they believe that they can get it done prior to the 2023 legislative session. What happens if they don't get done, I think it's a legitimate question that we would have to address during the 2023 session. But I mean, but fundamentally, the answer, if the argument is we shouldn't do a disparity study because it might be late, okay. I think that that we need to do. I think it's vital that we do the disparity study. It is vital that we go through those steps so that we can make sure that we are doing the licensing piece of this puzzle well, and that we are seeking to address those issues that I've discussed before.
Yeah,
And
Chairman,
I, yeah,
you know, I
get
understand what
your
you're
point.
saying, but we already know, right? I mean, this is not new ground for us, and that's, I think, why I think from an approach standpoint, there's been a little bit more look at, more comprehensive. I appreciate your answer to it, and we may be just kind of in a philosophical difference on it. I definitely understand.
No,
Thank-
I appreciate that.
Yeah.
Okay, now we're down to Reedy, Jennings, and Benson.
Thank you, Madam Chair, and thank you, Mr. Chairman. Nice to see you here. I was making a few notes. I have a couple of brief questions. It might take us a little different direction after that. So we could pass 837 without the referendum, correct?
You could, if you struck the language that made it contingent on
Well,
the
of course,
referendum
yeah,
itself.
we could, yeah.
The challenge there, I think, becomes, that you're taking out the voice for the people, the voice for Marylanders to actually speak clearly on the issue, which I think the speaker believes is very important.
I'm glad that you answered the question that way, because I guess my concern is, first of all, I don't like the idea of putting marijuana in the state constitution. I understand we don't really have a referendum process beyond that in the state, but to me, that this is an issue where people elect their representatives to cast a ballot, to cast a vote on tough issues, and we've seen the polling. I think, some of our districts, the district I represent, I think a lot of folks still have a lot of questions about it, but I think an up or down vote, I would feel more comfortable being able to say, we're voting to do this and put this program in place, as opposed to just, I feel like it's a little bit of are you concerned that it's a little bit of a shell game to say you're voting to legalize marijuana? In fact, as I look at HB1, I like the idea of putting the second part of HB1 in the referendum, saying, do you support legalizing, and then support the General Assembly putting in regulations in place, because you're leaving, by just simply saying, do you support it or not, you're leaving up, people are assuming that that's that. And I assume that would be a friendly amendment to alter the referendum language.
Well, I think that if what I think I heard you say was that it would change the question that would be on the ballot to, do you support the legalization of adult use marijuana on July 1st, 2023, is what I believe you're intimating to. I think that level of specificity might address some of the broader concerns people have about whether they cast a ballot and then they can immediately go out and start smoking marijuana.
Well, I think,
Having said that,
line 16 on page 1 of HB1 says that section B, the General Assembly shall by law provide, you wouldn't say by law in the referendum because that's why you're having the referendum, but the General Assembly shall provide for the use, distribution, I feel like at the basic level we ought to add something like that to the ballot language. But let me pivot. Echoing what I'm hearing from a couple of my colleagues, I feel like we've spent a lot of time in this committee, and I've spent a lot of time in a previous committee I was on, talking about minority disparities of outcome, disparities of how minority groups can participate in the medical marijuana process. I just want to echo, I'm trying to think how to phrase this in a question. I want to echo, why do we need another disparity study when we have a lot of evidence that we've had a big problem in how the medical marijuana process worked, to where originally there was literally 17 awardees and none of them, or maybe one of them, was African. I mean, do we need another study?
well, there was a disparity study done in the area of medical marijuana in 2017. The belief is that the market has significantly changed since 2017, that we need to look at it again. And we need to do that so that we have the data that we need to be able to go forward with a licensing scheme that can address either any existing or continuing disparities that exist that prevent the access of brown and black and other minority groups from entering into the process for the sale of adult use marijuana.
Okay, and Madam Chair, this is my final sort of series of questions here, because I'd like to do a little bit of discussion about the criminal side of this, or what we're doing on the criminal penalties.
Sure.
So, if the referendum were to pass under this set of provisions, possession of marijuana, 1.5 ounces of marijuana or less would be legal. And then between 1.5 and 2.5, you'd be civil
Be a fine
fine for possessing that much.
for possessing up to 2.5 ounces of marijuana, yes.
Above 2.5, you could still be subject to
You
what?
could still be subject to the existing penalty, which I
For
believe
PWID?
is, not for PWID, well, it depends.
Could be.
Could be. There's also language in there that explicitly says that that the sheer possession of under, I think it was 2.5 ounces of marijuana, just that was not enough to justify a charge for possession with intent. You would need to have something else on top of the possession to demonstrate possession with intent. Scales, lots of rolling papers, lots of other things that would have to be there so that you could go forward with that. But the idea would be that possession of over 2.5 ounces would still be a criminal offense. 2.5 ounces,
It's a good bit of marijuana.
it's 70 grams. And I'm aware I'm being videotaped, and people are going to say what they're going to say. I've heard of marijuana cigarettes. I've heard of marijuana cigarettes that are 0.5 gram. I've heard that they're a gram. I've heard they're 1.5 grams. I've heard people like a lot of them. I will tell you that I have not myself, and now here it comes. I've not myself used it, but having said that, generally speaking, 70 grams is a lot.
That's maybe 65 to 80 cigarettes or.
Could be anywhere
Even
from
more, maybe.
70 to 140.
Okay,
yes,
all right.
give or take.
So we want to, so that would be in a way of you arrest somebody on the street, you arrest somebody on the road that is transporting, 800 packs of cigarettes from another state. It's the same concept that somebody could still be arrested and charged. But it'd be a misdemeanor now, correct? Not a
It'd
felony?
be a
Or not
misdemeanor. If
it
they were
wasn't a felony
charged with
before, but-
possession with intent, would be a misdemeanor,
Misdemeanor,
yes.
okay.
And
What
it
if they're
would carry
just possessing
3 as
it?
opposed to 5.
What if they're just possessing?
I'm trying to remember whether, I believe it's still a maximum penalty of a year.
Okay.
If it's simple possession.
Okay. I think it's important to get that
Actually,
information.
I think it's 6 months. My brain just
Yeah.
stopped. It's 6 months.
It's
Sorry.
important information for people to know. The other question that I have, and I think I'll try to wrap this up, Madam Chair, much to your, I'm sure, appreciation. One of the things I liked when we decriminalized outdoor smoking was that we said that basically if you're caught without smoking a small amount of marijuana,
Yeah, okay.
that we're still going to have a very significant stiff fine of $500. And I believe it was a must appear, although as I look at the bill, it's not a must appear, right? For that, it's just a $500 fine.
I think it was just a $500
It's just a $500 fine. I like the must.
And it had to be charged by citation,
It has to be started by citation.
so they couldn't arrest them.
So they no must appear, okay. So we're taking that down to 50 for a first offense, 150 for a second offense. And we've heard from the chair, and I'm just reading up here about some of the potential dangers of secondhand smoke. And I think a lot of us that don't necessarily, whatever your position is on whether it should be legal or not, there's concerns about it being everywhere, smelling it. So what was the rationale with such a small fine, particularly for a second offense?
I will say the committee had a long discussion about the amount of the fine, and the question came back to, it comes to an issue of whether or not people, I mean, it's a question of, okay, this is a legal substance, how are we treating it? Are we treating it roughly similarly in some ways to open container? Are we not?
And the committee's consensus was to not treat it as roughly as open container?
Treat it with a lower fine and to treat it with
Really?
a subsequent fine for $150.
Because I feel like open container, I'm glad we have open container rules, but me walking around with a beer is not really bothering anybody's airspace. Whereas if I'm smoking a joint, walking down the street around families and kids, but anyway, I appreciate the answers. I was just curious about that.
I mean,
so.
you could argue that having open containers at the end of the Fells Point Pier and turning the end of the Fells Point Pier could be a bit of a problem too. I mean, that's one of the issues that we looked at as a committee. And fundamentally, again, one of the other challenges that we're seeking to address are to some degree unnecessary encounters between people and the police for what would be an illegal substance at that point.
Okay, thank you. Senator Jennings and Senator Benson.
Thank you, Madam Chair. Senator Reedy, actually, his last question was my question, but I'll kind of dive a little deeper on it, and here's my issue with it. And I'm more of a libertarian of do your own thing, but when it comes to open container laws outside, you standing on a street corner drinking your beer, you're not affecting anybody unless you get into a vehicle or do something. My problem with the marijuana or cannabis smoke is there's a lot of people that have clearances. There's a lot of people that they're in the military, that have CDL licenses, that have pilot's licenses, that they get tested. I'm one of them. If it's in my system, I'm gone, I'm done. There is no recourse for me. And I understand some of the studies say that, it's not likely that you will test positive. But I think with this becoming legal, it's going to be everywhere. I mean, you smell it now when you go out. Now that it's legal, you're going to have more people outside smoking it. And, I find myself walking the boardwalk or other places where as soon as I smell it, I literally hold my breath and walk faster because I'm petrified that when I go to the next drill, I'm going to get tapped on the shoulder to take, once every drill, we have to randomly people get picked. That's my concern with the outside, the outdoor. And, lessening the fine, I have a problem with, because to me, if you want to do it in your house, that's fine. If you want to do it anywhere else, but not outside where the public is, because it is impacting me. And, Senator, her district has the NSA, 30,000 people have clearances. We have a lot of military bases. As I said, that is the one issue that I have with it, that I would like that to be stiffer, because, standing outside smoking, you're going to impact somebody else that you might not know. And that's my one issue. I just wanted to say to my committee that I would like to see if we could push that back to where it was.
Not to make light of it, but we finally have an "isn't that so" question. I was feeling so far away from judiciary until just now. But with respect, Senator Jennings, I mean, look, this is an issue that does kind of go to the very core of what we're talking about here. And I'll say one thing. One of the things that we did learn through the process that we went through, studying the different aspects of marijuana and how other states have done it. So we looked at the public health impacts, and we looked at the increase in use after legalization compared to prior in the states that kept track of that. And the increase, I think some people think everybody's just going to go ahead and start smoking marijuana the moment that it becomes legal. I don't think that necessarily will happen. To your point, however, it'll be more prevalent out in public. And the reason that I mentioned that first part is that I don't think there's really solid evidence that has demonstrated a vast increase in the number of people that use it. But to your point, I mean, this was an issue that the committee, that my committee really delved into, and there were strong opinions on every side. It wouldn't surprise me if that were the case here, and I certainly look forward to working with you and others to figure out how we would go forward in that area.
Thank you.
Okay, and finally, Senator Benson.
Thank you very much.
Just one more? Okay.
Well, but we're going to add the vice chair.
All right.
Thank you very much for coming over.
Thank you, Senator.
Mr. Chairman, I had my experience with marijuana when I was out in Denver, Colorado. I had to go out to take care of one of my students, and coming back, I came past an open park. And it seems like everybody in the park was smoking, but when I got on the other side of the park, something happened to me. I thought I could walk to my hotel, but I had to be carried to my hotel. I had to be escorted, and it was as a result of the smoke from the marijuana. What my friends had told me was that I had gotten what is called a contact high. My God, I didn't need it, but that's what happened. The question I want to ask of you is this. I would think, I want to get back to the referendum. We've all had experiences with referendums when we go to vote. Some takes us a while to read, and even after reading it, with our intelligence, we still don't understand what the referendum is saying, what the particular item is saying. Have you all given consideration to public hearings as opposed to a constitutional to a constitutional amendment? Have you given consideration to public hearings? I think that might be a better way as opposed to the constitutional amendment.
I believe that what our intent, well, what I know what our intent was to give the people of the state of Maryland the opportunity to vote one way or the other as to whether or not adult use cannabis should be legalized. And so I believe that there will be a lot of conversation regarding whether it should pass or not, and whether there should be public meetings or not will, I think, just as with every kind of political issue that we've dealt with, there will be people talking about it, and there will be people disseminating information on both sides of the issue. So I don't know that needs to be specifically included in the bill, but I think it will happen as naturally because there's a referendum.
What I'm saying, as opposed to the referendum, I think it's better, to be quite frank with you, I know for my constituents, it would be better if we had public hearings whereby they would get a clearer understanding relative to marijuana, because I'll tell you, in many of our communities, there is a level of trust here. We know that something needs to happen, but most people are of the opinion that smoking marijuana leads to consuming heavier drugs, and it goes on and on. But I think the educational piece is very critical when we're talking about something so important.
Again, I think that I take your point. There's nothing in the bill as it stands right now that would set up public hearings, but
I can't seem to understand why we want to put it to referendum. That's very concerning. We already have the data. We've already done the study. I just can't seem to understand that.
I don't think that we have the data that we need to actually do the work that we need to do. I don't think we have that specific data. If you want to be able to address the underlying barriers specific to this, that's the critical distinction, and that's what we have to do legally. We have to legally go through this process and demonstrate, here are the barriers that we have to people who want to participate in the process. That's why the disparity study is important, and that's why we've laid it out in the way that we have.
Okay. All right. Vice Chairman Feldman.
Yeah, thank you, Madam Chair, and thank you, Mr. Chair. Just a couple things. I just wanted to, there was a lot of, in your testimony, a lot about what the House did and what the Speaker's position is. I just have to make the point that the Senate, and particularly this committee, last year we had straight-up legalization bills. This year have, Senator Carter has a bill, and I have a bill. During the interim, Senators Hershey, actually Senator Wallstreich just walked in, Augustine, Kramer. I mean, we spent a lot of time on this side, so I don't want the impression out there to the world this was just a bunch of House work groups and the Speaker's position, because we did spend a lot of time on this. I did have just one question it has to do with the fund. And I'm looking at specifically the Cannabis Business Assistance Fund. There's a provision in here that talks about may not award grants under that particular fund to small minority women, business owners, and entrepreneurs with a personal net worth. And then you specifically plopped in 1.7 million. It's kind of a random number. How did that number get arrived at?
We had talked to one of the sponsors of legislation in the House, Delegate Lewis, had done some work in this area, and they had basically landed on that number as being one that would distinguish people of a high net worth as opposed to not. And the net worth sought to reflect, I think in some ways there are some parts of the state where particularly real estate is more expensive than others, and it reflects that distinction.
Okay, Madam Chair, thank you. And look, I think we look forward to working with you on this. You see, some of the questions and issues that have popped up, and it's our two chambers here. So
yes,
I think that's one thing I just want to communicate. Thank you, Madam Chair.
Look forward to your bill. Thank you
you
very much.
We appreciate your taking the time to speak with us this afternoon, and you hear a lot of what's on our minds. And I think I'm a little bit smarter than I was when you started. Thank you. Okay. Thank you. Thank you. All right, the Senate Finance Committee is now in its voting session, and David has got the two bills that we're going to consider this afternoon.
The first bill on the list is Senate Bill 720. There's an existing Board of Examiners of Nursing Home Administrators. The purpose of this board is to regulate the folks who run nursing homes across the state. The reason why we have this board is because Medicaid, there's a contingency about any state that receives Medicaid has to have their nursing home managers are regulated. The bill expands this board to also regulate assisted living managers. So the bill renames the State Board of Examiners of Nursing Home Administrators to be the State Board of Long-Term Care Administrators, and requires that these individuals must be licensed by the board to practice as an assisted living manager in the state beginning on October 1st, 2024. The bill also alters the board structure, membership requirements, and other things relating to the fact that you're adding a whole group of folks to the regulation, to be regulated by the state. There were, the House worked long and hard on this bill throughout the session so far, and they have compromise amendments because there were some concerns from the industry, as there usually are when you start regulating folks. All those concerns were addressed in the amendments that that you see in front of you, and the House passed the bill, and it's actually over here. House Bill 1034 is over in the Finance Committee right now as amended. Very quickly, the amendments require that the Office of Healthcare Quality to notify the board if an assisted living program is appointed as a resident's representative payee. Last year, you passed legislation concerning that they would have to report to OHCQ. Now they would also have to report this information to the board. It requires assisted living managers employed by an assisted living program that is licensed for 4 or fewer beds to take a specified manager training course. Right now, this course is required for the larger facilities. This will require all assisted living facility managers to take this training course that's already existing, training course requirement that's already existing. It alters the composition of the board to account for the fact that they're also going to be regulating assisted living managers. It authorized, the amendments authorize an alternate assisted living manager to act as an interim assisted living manager under certain circumstances. The same requirement applies to nursing home administrators. Applies current exemption for the assisted living manager training course requirement for certain, that's what we just discussed. It grandfathers certain folks in who've been managing an assisted living program for a while. It strikes inconsistent education and training requirements. The amendments also lower penalties and establish a civil penalty for practicing as an assisted living manager without a license, except that an individual is in violation of the licensing provisions going forward. The terms of the board members are altered to account for the addition of 5 new assisted living managers, and a reporting requirement is added.
Okay. Move favorable. Second. All right, we got a motion and a second. Is there any discussion on the motion? If not, all in favor, please raise your hand. Okay.
Senator Benson also wanted to be on the bill, so she's in the amendments you have before you, so we'll also add Senator Beidel. Anybody else?
Okay.
No? Okay.
All right, thank you.
And if you want, since the House bill is already here and it's identical to this bill, if you want to vote that one right now, that would be House Bill 1034. That would be a favorable.
It's been moved.
We're not going to report it out. We're going to just to get it vote, just to get this process going, but it won't be reported out.
Okay.
We'll wait to see if we get some good treatment on the other side.
This is just something to get going now, and then we're going to, well, one, we can't do it because we don't have the revised fiscal note, but also, you know, it can be,
But
it
it'll
can be
save
held for
us
later.
time
You're
later.
voting it now to get it out.
Watch out for my chair's bill.
Okay. All right.
So everybody vote on the House?
Yeah,
Same vote?
yeah.
The next bill on your list is Senate Bill 955. This was heard yesterday. What this bill does is, last year or 2 years ago, you There were some changes to the personnel status of the folks who work for the Maryland School for the Deaf, and there was a separate, the folks who were considered faculty at that school were added to the was specifically added to the state personnel management system, and also they were given collective bargaining rights. Along with those changes, the rest of the school was also brought into the state personnel management systems, but what this bill does is it specifically states in the education article and the provisions that govern the school that those all employees there are in all professional employees and staff employed by the school are in the professional and skilled services in the state personnel management system. They're already there now, this just specifically says that they're there now. It also requires that these folks be accreted into various bargaining units based on the type of job they do. They're there now, but this just, clarifies that this process had to occur. So that's what the bill does. It basically clarifies or specifies all the existing provisions that have already happened to these employees.
Okay, do we have a motion? Move favorable. All right. Is there a second? Second. Okay, we've got a motion and a second. Any discussion on the motion? All right, if not, all in favor, raise your hands. Okay, we'll need to call a roll.
Senate Bill 955, favorable. Senator Feldman? Aye. Senator Klausmeyer?
Yep.
Yes. Senator Benson?
Yep.
Yes. Senator Hayes?
Yes, ma'am.
Yes. Senator Reedy?
No.
No. Senator Augustine? Yes. Senator Beidle? Yes. Senator Hershey? No. Senator Jennings? No. Madam Chair?
Yes.
Yes. Bill passes.
Okay.
For the House bill with the same vote, it's here in the committee already, and it won't be reported right away.
Okay. That saves time. Okay. All right.
That's House Bill 374, for the record.
Okay.
And that would be favorable.
Okay, that ends our vote.
All right, this ends our voting session